This courtroom session starts like many others, but within moments, it spirals into something far more intense. On one side, a man accused of assaulting a pregnant woman. On the other, a judge who refuses to simply go along with what's written on paper. At first glance, this might seem like a routine plea deal. But look closer, and you'll see the tension building. The victim herself requested reduced restrictions. The defense wants to move forward quietly. But the judge? She's not convinced. Not even close. Because here's the real question. Should the system bend when the victim asks for leniency, or stand firm when the facts suggest something darker? And just when you think you understand where this case is heading, another case enters the courtroom. This time, a 17-year-old facing life-altering consequences for aggravated robbery. Two different defendants. Two very different crimes. But one powerful courtroom, and one judge who isn't afraid to speak uncomfortable truths. Stay with me, because what unfolds next isn't just about justice. It's about accountability, consequences, and the choices that change lives forever.
23 CR 3546, State of Texas versus Larry Casillas. Can I have parties announced for the record for the state?
Thanks to the state of Texas.
Defense?
Elizabeth Russell for Larry Casillas.
Are you Larry Casillas? Counsel, have you received all the discovery? Did you review it with your attorney?
I have reviewed.
I'm sorry, with your client.
Yes, Judge.
Court will find that the state is in compliance with discovery. Showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Um,
That appears to be a yes.
That's it. We're proceeding on count one.
All right, there's only one count in the indictment.
Yes.
All right. Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault of a pregnant person? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Let's pause here for a second, because what just happened is critically important. The judge confirmed that the defendant understands the charge, assault of a pregnant person, a third-degree felony. That's not minor. We're talking about 2 to 10 years in prison and a possible fine. Now here's where it gets interesting. Everything up to this point is procedural, standard courtroom flow. But beneath the surface, the stakes are already high. When someone pleads or considers a deal in a case like this, they are not just accepting punishment, they are shaping their future. And here's a question for you. If someone commits violence against a vulnerable person, especially someone pregnant, should leniency even be on the table? Because what comes next, the judge's reaction, changes the entire tone of this hearing.
Did you understand?
Yes, ma'am.
All right, we can go off the record. I'm looking at this plea bargain agreement. And there's to be no harmful or injurious contact with Stephanie Ortiz.
That's her by her request, Judge.
I'm not following. I'm not going to follow that.
Even though that's her request.
No, I mean, no, even though it's a request, according to what I'm about to receive, he is a person who is hitting on, not in a loving manner, a pregnant person. I mean, was she pregnant at the time?
Yes, Your Honor.
So if, you know.
She's requesting, and I'm sorry, Judge, may I speak?
Sure.
She's requesting it for her convenience. They've been doing custody exchanges for the last almost a year through a third-party person, and it's her request. She reached out to me, filled out an affidavit of non-prosecution, and requested that. So
I'm not following that.
This is a turning point. The judge just rejected a key part of the plea agreement, even though the victim requested it. That's huge. In many cases, courts consider the victim's wishes. But hey, the judge draws a hard line. Why? Because the allegations involve repeated violence, and not just against anyone, but a pregnant woman. This shows something powerful about the legal system. Judges are not bound to accept plea deals if they believe justice isn't being served. Think about that. Even when both sides agree, the court can step in and say, no, this isn't enough. So now the defendant faces a choice, accept stricter conditions, or risk going to trial. Let me ask you this. Do you think the judge is being too strict, or exactly as firm as the situation demands?
So if you all want to withdraw your plea now, you can, but I am not doing a no harm for injurious contact for somebody who's accused, and I haven't read the steps yet, who's accused of hitting a pregnant person?
That's fine, Judge. They're no longer in a relationship. The only relationship is for the benefit of their children. He has no interest in communicating with her beyond that.
All right, so I'm not going to follow that. So y'all have a choice. Either you can go to jury trial, or either you all can change that part of your plea bargain agreement.
We're proceeding with the no contact, Judge.
All right, if you all want to change that. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, we would just request that you follow the agreement between the state and defense. Mr. Casillas is wanting to move forward in a direction that's appropriate for his children. He understands what went wrong, and he wants to take full responsibility for that. And he has had no issues since the arrest on this date, and they have been successfully co-parenting since that time. There was a CPS case, Judge, that was closed out for no finding.
All right, how old are you?
21, Your Honor.
How many children do you have?
2, Your Honor.
What are their ages?
1 year and 6 months.
1 year and what?
1 year and 6 months.
Are you employed?
Yes, Your Honor.
What do you do?
I work at Amazon at Facility Warehouse.
All right, so why do you keep hitting on Stephanie Ortiz? At one point, I'm assuming you loved her because you have children with her.
Yes, Your Honor.
So why do you keep hitting on her?
It was just me not being in the right state of mind, me letting my feelings get to myself and not just thinking right and thinking straight.
That makes no sense to me.
Your Honor, it was just my fault. I let my feelings get to myself, let her get in my head and
Let what?
let her get in my head, and I just reacted in a wrongful way.
No, but I mean, you're up here hitting someone. Honestly, I don't even know why I should follow this plea, but your attorney is telling me that she's filed a affidavit of non-prosecution. But according to this, she was pregnant and she was going to be induced that day, and you decided to put your hands on her. I don't understand how is she getting in your head that you would be hitting a pregnant woman.
This moment right here, it's not just legal, it's deeply personal. The judge isn't just reviewing facts anymore, she's confronting behavior. Notice how she challenges the defendant's reasoning. She got in my head. That explanation, it doesn't hold up under scrutiny, and the judge makes that clear. But then she goes further. She brings in the impact on the children. That's a powerful shift, because now this isn't just about what happened, it's about what's being taught. Violence doesn't exist in isolation. It creates patterns. It shapes what children see as normal. And that question she asks, what if your daughter ends up with someone like you? That hits hard. So here's something to think about. Is punishment enough, or should moments like this be about forcing real reflection and change?
Who's about to deliver your child?
No, Your Honor, what that day was in the day we were supposed to get induced. But I believe the hitting was before that. So it was just the marks that had came about.
But you still hit her while she was pregnant,
Yes.
and she was close to her due date.
Yes.
Not that it's appropriate to hit anyone anyway,
No, it's not, Your Honor.
but obviously she was pregnant. And what she's saying in this documentation, I want you to tell you the reason why I'm saying no contact,
Yes, Your Honor.
because what she's saying in this police report is this is not the first time that you've been abusive to her. And the police took photos, and she had bruising and swelling to the eye, along with busted vessels in her eye. That's what you did. So the 2 children you have, is this a boy and a girl, or 2 boys or 2 girls?
Girl and
All right. So what's your daughter's name? Sarabella.
she's a year and 7 months.
All right. So she's a year and 7 months. I guarantee you she knows that you've been abusive to her mom. Do you love your daughter
I love her with all my heart.
with all your heart? Would you do anything for her?
I would, Your Honor.
I used to do CPS cases, and parents would tell me I will walk through fire for my children.
Yes, Your Honor.
They would say that because they knew nobody had a fire for them to walk through.
Mhm.
But I believe you when you say you love your daughter.
Yes, Your Honor.
So how would you feel if your daughter became of age and she ends up with somebody like you who hits on her? Would you be okay with that?
I'll be very upset, Your Honor.
And so your daughter is learning what it means to show love is to hit on people, and might makes right.
Your Honor, that's
You're going to have to change your ways.
yes,
You are not.
All right, let's break this down clearly, because the sentencing here is layered. The defendant receives 6 years deferred adjudication. That means no immediate prison time, but it comes with strict conditions. If he violates them, that prison sentence becomes very real. Now look at the requirements. No contact with the victim. Mandatory BIPP program. That's a battery intervention. Parenting classes. 200 hours of community service. Regular drug testing and monitoring. This isn't just punishment, it's structured rehabilitation. But here's the key takeaway. The judge is balancing two things, accountability and opportunity. So the real question is, will this second chance lead to change, or is it just delaying a harsher outcome?
Not to have any contact with Stephanie Ortiz. And anybody else you get into a relationship yet, don't let them meet your publicist. Let them meet you and tell them, hey, want to let you know I had this abusive acts in my background, because then they can make an informed decision about whether or not they want to date you. You understand?
Yes, Your Honor.
All right, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's to be no contact with Stephanie Ortiz. There's to be the BIPP course, parenting classes, that can be with rainbows. There's to be 200 hours of community service restitution. That will be waived once he completes parenting classes. Regular reporting by Zoom or in person. Regular UAs. If you're drug tested today, what are the results going to be?
Positive, Your Honor.
And what are you going to be positive for?
No, negative, Your Honor.
Negative? Okay. So you haven't used anything.
No,
I think Amazon drug tests, do
yes,
they
yes,
not?
Amazon drug test, yes, ma'am.
All right, there's to be regular UAs. I'm going to want field visits one time every 3 months. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. There's an affirmative finding of family violence. Probation, is there anything else he needs?
You already did mention the regular.
Yes. All right, is there anything else you need from the court in order to be successful?
No, Your Honor, thank you.
Showing you what's calling 2023 CR 2528 and 2023 CR 2529, State of Texas versus Berlio Marquez. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
Robert Maurer for defendant, Your Honor.
And are you Mr. Marquez?
Yes, ma'am.
Counsel, have you received the discovery in each of these cases, and did you review it with your client?
Yes.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, in each cause number, do you waive the reading of the indictment?
I did.
State, are you proceeding on the indictment as presented in each cause number?
We are, Your Honor.
Mr. Marquez, in each cause numbers, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review those documents with your attorney?
Yes,
Did you
ma'am.
understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
Did you understand in each cause number, you're charged with the offense of aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you?
And just like that, we move into a completely different case. But the intensity, it doesn't drop. This time, it's a 17-year-old facing aggravated robbery charges. First-degree felony. That's serious. 5 to 99 years or even life in prison. Think about that for a second. 17 years old and already standing in a courtroom where life sentences are on the table. The judge follows a plea agreement here, but the consequences are still heavy. 5 years in prison. Now compare this to the previous case. One defendant gets a chance outside prison. This one, immediate incarceration. Why the difference? Likely the nature of the crime, aggravated robbery, possibly involving a weapon. So let me ask you, at 17, should someone be given more leniency or held fully accountable like an adult?
You understand? After reviewing State's Exhibits 1 and attachments in each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge, but ask to waive PSI.
Anything you wish to say on behalf of your client?
Just ask you to follow the plea bargain here.
All right. And the cause number ending in 2528, the court will find you guilty, sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 2529, taking consideration 2023 CR 2621, 2527, 699-185, and 184. There's to be restitution, if any, to Isaac Cervantes, Cameron Carroll, Kyle Sutherland, and Stephanie Lefevre, and also no contact with any of those parties. And then in cause number ending in 2529, court is finding you guilty, sentence you to 5 years in the prison, credit for any time served, concurrent with 2023 CR 2528, taking consideration 2023 CR 2621, 2527, County Court Cause number 699-185, 184, no contact, and restitution to the following: Isaac Cervantes, Cameron Carroll, Kyle Sutherland, and Stephanie Lefevre. I'm pronouncing that name all sorts of ways. I apologize to Stephanie. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're off the record. How old are you?
17.
You're 17 and you're doing this foolishness. Things, if you want things, you got to get a job so you can have things. You understand?
Yes, ma'am.
For a 17-year-old, you've chosen a hard road for yourself because you're going to prison, 17. And you're going to be in prison with a bunch of people who are there for murders and other things. When you go to prison, don't become institutionalized. You're 17, you still have a chance to make something out of yourself and do better in your life. So keep your head down and do your time and try to improve yourself. You can even take college classes while you're at the prison. And if you dropped out of school and don't have your high school diploma, you can get your high school diploma while you're there. So don't come out of prison having just wasted time, okay? All right, good luck to you.
Thank you, Judge.
What we just witnessed were two powerful examples of how justice can take very different paths, depending on the circumstances. In the first case, the court chose structured supervision over immediate punishment, but with strict conditions designed to prevent further harm. The judge made it clear, violence, especially against a pregnant woman, will not be minimized, regardless of personal requests. In the second case, the outcome was far more severe. A 17-year-old now faces years behind bars, reminded that choices made early in life can carry lifelong consequences. Both cases highlight a critical truth. The courtroom isn't just about laws. It's about judgment, discretion, and the human impact behind every decision. Now I want to hear from you. Which case stood out to you the most? And do you agree with the judge's decisions? White right pointing backhand index. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
May I be excused?
Yes, thank you, Mr.
Thank you.
Maurer.